Great. Good morning, everyone. I'm Tom. I'm one of the co-founders and executive chairman at CertifID. For those of you I have not had the pleasure to meet, welcome to our Sued for Wire Fraud podcast. Every month, we do try to bring you fresh insights and content that you can take back to your organizations, to your referral partners, and ultimately your customers to make them more safe and engaged around what is an ever-evolving landscape on wire fraud. And today we are going to profile a project that Will and Claudia and others and I worked on for months. And that was a review of all court cases, state and federal, surrounding litigation involving real estate and wire fraud as the risk profile leading to litigation. So essentially the question was, a wire fraud took place, who's responsible? And we're going to dissect that both from an incoming and kind of an outgoing funds transfer. So to jump right in, this is an alarming trend. The IC3 report and everything is supporting that. I won't belabor it, but you can see the quote here from Katie, who currently leads the U.S. Secret Service's Global Investigative Operations Center. Real estate is continuing and will continue to be an incredibly large vector of fraud attention for the bad actors and the cyber criminals. You can see based on that report, both our report, the Alta Critical Issue Study on Cybercrime, and the FBI Public Service announcement that came out, real estate had just under $500 million in reported loss. Again, that as a reminder, that's probably 20% of what's actually happening. Title companies and law firms, about just over 15% sent to a wrong account, some funds out of the IOLTA or escrow account last year. And in our study where we polled consumers, 1 in 20 became some sort of a victim during a real estate transaction. And because of all the parties involved and the amount of money at risk, again, it's a continual solicitation of bad actors trying to divert funds. So why real estate? Just as a reminder, publicly available information on the MLS leads to kind of an active deal board. They understand the median sale price. I think now is higher than that based on a recent report. I think we're back right around the high 3s or low 4s in most market for existing home prices, and just the multiple parties in a transaction. Remember, if one party is compromised or somehow breached in any way, there's like this exponential risk effect that takes place on the rest of the transaction participants. By the numbers, the loss vectors kind of track the conventional mortgage loan amounts and net proceeds. And what I mean by that is when we look at our fraud recovery services team stats from last year, the median loss to buyers was $72,000, to sellers was $70,000. And again, that tracks like cash to close versus net proceeds after closing and all payoffs and commissions and fees. The large vector really is that mortgage payoff. We're gonna profile a case on this. That was a $257,000 median loss, really facing the title company or the closing attorney that's charged to administer that payoff wire in a safe way. So everyone's a target, either in seller impersonation. We won't get into that much. We did that on a previous webinar, and tune into that if you were not there. The seller impersonation is another huge issue. So the question is, and for those of you a little more backgrounds, I'm a large title agency owner here in Michigan under Sun Title. I have my real estate broker's license. I'm also a member of the Michigan Bar. So as we look at this, I'm kind of living and breathing this on both sides, the certified and the title company side along with you every day. And we wanted to do an appropriate job of framing a question or an answer to the question of just simply who's responsible after one of these takes place. And what I hope you'll take away from today is the idea that there are clear lines of liability that are being drawn in the courts, and there's something fuzzy as it relates to consumer protection. So the clear line is if you have money in your escrow or IOLTA account and you're responsible for dispersing those funds, it's essentially strict liability on you. Flat out, strict liability. And I'll show you why that is in these opinions. As it relates to the consumer, there's a heightened standard of care that's evolving, but the courts are struggling with that evolution on how far they need to go. How far does a title company, how far does a real estate brokerage, how far does a real estate agent need to go to protect the consumer and set them up for success when, after all, it is the consumer's responsibility to get the money safely in for closing. So if you have to tune out early, those are the two bookends. The consumer, there's an argument to be made that surviving summary disposition and a quick exit in favor of title companies, but title companies and law firms have a tough go if they've received the money and they lose it on a send out or any type of disbursement wire. So let's just talk about liability real quick. These aren't all of them, but these are some of the major forms of company liability. Contractual, tort, those are typically party to party and personal in nature. Regulatory, statutory, could be more government related in fines and penalties and other. You always say have employee liability and product and tax and debt and things like that. But we're going to focus and why they're highlighted on the contractual and tort liability, because they do play an interesting role in how courts are just wrestling with these theories that are pled. And when I say theories pled, for those of you that didn't endure law school and you're smart not to, there are theories of cases. And when a plaintiff files a lawsuit, there are counts or theories that are pled, and you can plead multiple different theories in multiple different counts. And most plaintiffs' attorneys will draft what I call a kitchen sink pleading. Every conceivable possible argument in a theory will be included. And these are the top four. Negligence. So negligence is a tort, and it basically says there's a duty someone owes, there's a breach of that duty, there's causation, meaning the breach led to the harm, and there was actual harm. So duty, breach, causation, damages are the four elements of all negligence cases. And companies, does the industry owe a duty of care, a negligence standard that we have to cross over for consumers or for those that we have been trusted to disperse funds in favor of. Deceptive business practices, that's called UDAP. And that's where companies may be holding themselves out as one thing, but in reality are providing a completely different service or a completely different experience. You'll see here that those fall apart in these cases, because this isn't about, I sell living water and it will make you live longer versus just tap water that I'm bottling with a fancy label. That would be a deceptive practices. We're not doing that as an industry. And while they're pled, you'll see they fall apart really quick. Breach of contract is different though. So there are three types of contracts in most cases. There are oral agreements. So I agree to my colleague Will, that's hanging out with us here, to do something in exchange for something else. So I'll perform a service in exchange for payment. We can have an oral enforceable agreement. Then there's written. In real estate. I think in almost all states, real estate contracts have to be in writing under the statute of frauds, or they can't be enforced. Or there's implied. And implied is just looking at the behavior of the parties, looking at kind of the natural rhythm of an industry, and courts can imply or impute a contractual relationship without anything spoken or anything written. And you'll see how this plays out in the consumer segment of our analysis of these cases. And then you have breach of fiduciary duty. So that is also essentially a negligence claim, but it's a heightened standard. So a simple person might owe some level of duty, but somebody that's holding an escrow or IOLTA account may have a heightened standard of duty because of the special position or knowledge that they hold or would be imputed to hold based on how the courts are interpreting the fact pattern. So I know that was a lot, but that really is kind of the four elements that we saw. And there were others. I mean, some of these pleadings were bad: fraud, concealment. Some of them got really nasty, but these are the four that we're gonna focus on. So let's talk about banks and funds transfers. And I will admit, it drives me absolutely crazy that we don't have a better system to protect customers and companies in the real estate and title space against, banks receiving funds, and you think, man, clearly this is fraud. Clearly there's something going on with this receiving account. And the standard really is governed under the Uniform Commercial Code, Article 4A, and the Uniform Commercial Code has been adopted in some variant by all 50 states. So while there's a federal Uniform Commercial Code, it's codified at an individual state level. And I encourage you to find that codification in the states that you operate to make sure you understand what those standards are. I failed to mention, if you have a question, put it in the chat, because I have the chat panel open. I'll also open up the Q&A. So as we go through this, I have the Q&A panel up on another screen here. I'll gladly kind of look at questions, and Claudia or Will can interrupt as well if something comes in. So parties whose conflict arises out of a funds transfer have to look at Article 4A and how to resolve these claims. Article 4A, and this is from the Uniform Commercial Code, essentially governs the rights and responsibilities of parties involved in electronic transfers. It's not only a big bank thing, it's even smaller financial institutions, corporate entities such as ourselves, high net worth individuals, and payment processors or aggregators. So it essentially is the rule, the federal law codified at the state level, that says if it's an electronic funds transfer, this is the law that governs the rights and responsibilities of the sender and the recipient, not only parties, but institutions involved. What's missing in that, and I'm not trying to indict the UCC, that was one of my favorite courses, was Secured Transactions in law school. It was a full year. Is that in a world of advanced social engineering, in a world of being tricked, the UCC really was meant to say, look, it didn't, there was no concept of, well, somebody could be tricked and voluntarily be sending money to a fraudster, but they don't know it. That's not what the UCC was intended to protect in any manner, and you'll see this. It was intentionally providing a framework that as we move from a paper to an electronic form of money, essentially, and allowing more friction-free movement of money between corporate entities that you see here, can the banks, can the financial institutions releasing and receiving funds have a framework and a foundation to be able to build their systems and standard operating procedure without liability in the rear view catching up with them and having to change that in real time in the courts. Okay, and I'll get into this. But there's no mandate of account matching. So sender sends to, Acme Title, and the actual bank account number is going to John Doe. No account matching requirement at all in Article 4A. No duty to vet new account openings outside of Know Your Customer. So Know Your Customer is, are you a bad guy trying to open an account? Okay, if you are, then you're not going to open an account here. But it doesn't get into the intent of what the account is going to be used for. And there's no requirement to identify, monitor, or report any suspicious activity or anomalous behavior in any way. So let's look at cases involving financial institutions and can they be liable. And at the end of this, you'll receive a QR code to download our most recent Sued for Wire Fraud report. It has all the case citations for those of you on the legal side that kind of want to nerd out and read these. My desk is full of these because I had to go back into this material this morning. They're very interesting, and they're hard to read in a lot of cases because you think, man, the bank, come on, there's got to be some liability. So here are the cases. I want to profile a couple of them. Approved mortgage versus Truist Bank. So this is going to be a little bit of a law school session, guys, where we dissect some fact pattern, what were the arguments, and how did the case land. So I remember IROC, issue, rule, analysis, conclusion in law school. So here we go. The background of approved mortgage is their system was compromised. And as part of that compromised system breach, some payoffs that they were doing a refinance and they were paying off the existing lender on 2 files. The mortgage payoff statements from the existing lender were tampered with, and they ended up dispersing to fraudulent accounts, both held in Truist Bank. Okay, so that's the setup. They sued Truist based on negligence. Okay, saying, look, Truist, you should have done more. I'm going to read to you, this is the actual most recent court order, what they sued them for. And I'm reading this because those of you that are like me, you might be an attorney, you're certainly in the title space or real estate, you think these are common sense things that the bank, Truist, should have provided them. Count 1, asserts that Truist violated the Indiana Uniform Commercial Code by accepting the wire transfers, quote, despite them referring to a non-existent or unidentifiable account, and despite the fact that the beneficiary information listed on the wire transfer instructions bore no similarity to AER operations account information, meaning there was a completely different account name. That was count 1. Count 2 asserts that Truist violated the code again because it accepted the wire transfer even though it had actual knowledge that the beneficiary name listed on the wire transfer and the account number identified different people. Like, this is not our account. It wasn't for a payoff. It was for an individual account. And then the third, a common law negligence claim against Truist, stating that Truist had a duty to act in ordinary care using sound banking practices and act in a commercially reasonable manner, and that Truist breached that duty in 3 ways. So listen to this. Failing to detect and flag AER operation accounts as suspicious and accepting wire transfers despite obvious indicia of fraud. Giving this individual that once the transfer came through, there were cashier's checks pulled out immediately, giving this person almost $550,000 in cashier's checks without questioning him at the branch. And 3, failing to implement and adhere to security procedures to properly detect and flag suspicious accounts or activity. Truist sought dismissal on all 3 counts. And Truist won on all 3 counts. And this is what the court said at the end of the analysis. Our recognition of the common law negligence action asserted by plaintiff in his individual capacity would contravene the essential objective of UCC Article 4A. So they're citing a different case. And this is the sentence that they hung their ruling on. To provide definitive principles that allocate the risk and define the duties of banks affecting electronic transfers on behalf of their customers. Period. So Truist in this case was able to essentially get out of the lawsuit early on what's called summary disposition. And summary disposition has a high bar. It essentially says the court has seen enough evidence on both sides that there is no issue of fact that we need to go further. And the defendant is entitled to have this case completely dismissed. And notwithstanding everything that I told you there, the court agreed that under Article 4A, there's nothing here to talk about. So that was the Truist case. Fragali versus Wells Fargo. And if you have questions, please put them in the panel. Fragali versus Wells Fargo is, here's an individual that was buying a home and fell victim to a buyer side scam. So his closing funds were diverted to a Wells Fargo account and then quickly withdrawn. and he sued Wells Fargo for negligence, okay? But he wasn't Fergali was not a customer of Wells Fargo. He banked somewhere else. So Wells Fargo was just the receiving bank, and the plaintiff, Fergali, was banking with someone else. I want to read to you from the pleadings. You can read the slide there. I want to read to you from the pleadings some things that stood out. Beneficiary bank did not have a common law duty. So a beneficiary bank is the one where the money is being sent to. Did not have a common law duty under Pennsylvania law to avoid creating unreasonable risk of harm to originator of wire transfer, and thus the bank was not liable in negligence for its intermediary role in fraudulent wire transfer transactions perpetrated by a third party against originator, where there was no relationship with the bank and the non-customer originator, and the bank took no affirmative action towards the originator that created special relationship with an increased risk of harm. What does all that mean? It says, look, plaintiff, I don't have a relationship with you, says Wells Fargo. You're not my customer. Your bank, on your recommendation and your approval, sent money from your bank to us, and I don't owe you in duty. And then it goes on to say, even if the bank knew that nefarious individuals regularly opened accounts to perpetrate fraudulent schemes, such risk and foreseeability were too vague to show that the harm to the originator was foreseeable in the first instance. So foreseeability is this legal claim that if you're going after tort, you have to show that it was foreseeable, like it was likely that whatever the bank did or didn't do, in this case it was Wells Fargo, would have injured Fergali in some way. I'll finish with this quote here. Plaintiff argues that Wells Fargo is similar to another case that they're arguing because Wells Fargo subjected plaintiff to an unreasonable risk of harm when it improperly opened a fraudulent account that facilitated a cybercrime and failed to monitor the subsequent transactions for fraudulent activity. So what he's saying is you opened an account, it was going to be set up for cyber fraud. Cyber fraud was running through it. And Wells Fargo, you did nothing. You just stood on the sidelines. The court says, unlike this other case, which involved the relationship and duties owed, here there is no relationship, contractual or otherwise, between Wells Fargo and the plaintiff non-customer. So what this case shows, and it was interesting how they got there, is that Wells Fargo owed no duty because Fergali wasn't a customer. This was the bell ringer for me. Further, the burden of imposing a duty. So the court goes further and says, look, even if there was, let's just talk about the duty that you're claiming should be on the Wells Fargo side if you were a customer. So they go on and say, further, the burden of imposing a duty on a Wells Fargo to pause and consider before permitting such withdrawal of future untraceable funds merely because the withdrawal is large and was preceded by funds transfers to a new account is significant. Imposing such a duty would, quote, inevitably force banks to restrict their clients' accounts on the least degree of suspicion, thereby alienating their customers in order to avoid unspecified liability. Superior Court's decision in Commerce Bank, this court declines to make banks the guarantors of their clients' trustworthiness. I'm going to say that again. This court says, we decline to make banks the guarantors of their clients' trustworthiness. That is I find it to be an incredibly alarming and strong statement. And what that means is we're not in the business of determining intent. We're not in the business of opining on whether or not activity that may be out of the ordinary on the account is trustworthy or is fraudulent. So what we can learn from these cases is the banks have almost full immunity, receiving banks in particular, for unauthorized transfers. And UCC is very clear. It says, look, if you're the bank where your customer is initiating funds from, and you can show that it was an authorized representative of the account requesting the transfer, the liability essentially stops there. So where it goes, what happens after it lands, even if they're on notice that a fraud took place, there were cases we looked at where the banks just refused to do anything after they were alerted to a wire fraud. So no common sense practices like alert. Now, do some banks do it? I'm not trying to indict in any way the banking community. There's so many millions of transfers taking place every day. But their liability under 4A essentially stops at the sending level if it's the representative of the account that's authorized to release the money, at the receiving level if the ABA and the account number match within the bank. So you can see efforts to kind of change this practice. Now, there are some notions, there are attorney general opinions and some other letters being written to banks to say, hey, could there be something more that you could do to protect victims against electronic wire fraud? But the courts are not there yet, not by any means. So the takeaway from here, especially if the money is leaving your IOTA or escrow account, is it's going to be strict liability. You send to the wrong account, you're going to be on the hook. And while you may be able to sue and there's maybe insurance or contributory negligence by somebody's account that was breached that led to it, I think you have to take the position that it's going to be on your shoulders. All right, if there's any questions there, throw them in either the chat or the Q&A. Now, is there an exception? I always like to say, okay, but, right, like a normal lawyer would. Well, it depends. There's one case that we found, Studco Building Systems versus First Advantage Federal. So Studco Building Systems was paying a large invoice to a vendor, over $500,000. And they set up an ACH, which was coded CCD. This is a nuance, but I want to raise it. CCD means only for corporate credit or debit purposes. And the NACHA rules, which govern ACH, says if you initiate an ACH and you code it as CCD, it cannot be deposited into a personal checking or savings or any account. In this case, First Advantage did do that. The court looked at that and said, okay, you were on actual notice. The account had already been flagged for suspicious activity. So there's a whole other bunch of stuff going on. But ultimately, the court looked at that violation of NACHA rules and let it go further than just a summary disposition. But that's the only case we found where a company successfully was able to avoid summary disposition and take it a little further against a financial institution. All right. Our next favorite topic are insurance carriers. So we have all these forms of insurance. We have E&O, we have D&O, we've got fidelity, cyber, general liability, employer liability, workers' comp, right? It goes on and on, depending on what state you're in. I'm going to focus on the three top ones there. So E&O, just as a reminder, is to essentially discharge your professional obligations and standards as a real estate brokerage, as a real estate agent, as a title company. Some of those standards are codified in the occupational code of your state. Michigan has a great occupational code, especially for real estate agents and brokers. It could be codified through insurance regulations, through underwriter agreements that you'd have with agency, through common practice or common law. So think about E&O is, what's the role of X, and am I discharging everything that I need to, mostly to the consumer, as it relates to those standards. So it's like insurance for me doing my work right, is how I think about it. Fidelity bond is your inside job. You have an employee that absconded or diverted funds and otherwise embezzled funds. And there's a special insurance or bond in some states that protects third parties in case you have kind of, I call it the inside job insurance. And then the catch-all basket is cyber. And I say that because E&O, in a lot of ways, pivots, anything electronic or electronic funds transfer or data breach or system breach or loss and reporting and postmortem, I could go on and on to all things cyber. Okay. General liability and the rest of it. General liability is like slip and fall. My building blew down. I had a lightning strike, and the rest of it is more employee related. So let's dive into this. The first thing is that you have to understand the construct of an insurance policy. So in this visual, and I apologize if it's somewhat small, that's my certificate of insurance for Sun Title Agency here in Michigan, my insurance agency. And a lot of times we just look at this, we look at the boxes checked and the numbers, and we go on and we say, okay, I'm insured. But the insuring agreement has 4 very important provisions in them that you have to understand, especially as you're lining up standard operating procedure and whether or not you're covered in the event of, and then you fill in the blank. It defines coverages. What are we covering under this policy? That coverage has a bunch of defined terms. So you got to go to the definitions and understand the scope of a covered claim or a quote unquote loss or quote unquote damages or quote unquote notice and those types of things. And then what the bold print giveth, that's what that is. The fine print taketh away. And that's the exclusions and the conditions to coverage. So you'd say, okay, if you stopped at the definitions, okay, I got my head around that. I'm feeling pretty good. Till you get the exclusion section and it says, look, nothing related to an electronic systems breach, nothing stemming back from electronic transfer or wire fraud. And then if you do have coverage for any of it, what do I need to demonstrate and show the adjuster that I did that complies with the conditions of coverage? So not to get too technical, we could do a whole nother hour on insurance. And then the forms are attached, and you got to look at the forms, guys, because some of these policies are a bit antiquated, and then they true up either the scope of coverage or definitions or exclusions in what are called the forms. Our policy has like 15 forms attached, and the forms essentially redefine coverage amounts, redefine some specific exclusions and conditions. You got to look at the whole thing in totality. And again, that will limit or expand coverage. Claims are denied unless specifically covered. That's what we're learning in our court analysis about, and typically it was a title company or some insured suing their carrier, not necessarily the agency, but the carrier for denying coverage. And this is called the 4 corners rule. So the 4 corners rule basically says, here's a piece of paper, and let's call this our insurance agreement. And there's a lot of words on this thing. And we're going to look and interpret those words. And we are not going to bring in any other evidence, either through course of performance, either through testimony, what my agent said to me orally. We're going to strictly look at this document to see if there was coverage and if the denial was justified based on the 4 corners or the terms set forth in the agreement. So there is clear, firm precedent in court on these things. If I won't bore you with all the insurance claims because there were a lot of them that we looked at. It was a rinse repeat at the court level. You said you had coverage for wire fraud. There was no coverage. In fact, it was specifically excluded. Or there was some coverage, even though there was a sublimit, but you didn't make the callback procedure that was a condition. Or you made the callback, but you didn't have documentation that you made it from an independently verified number. And on it went. So again, I couldn't stress enough sitting down, making sure you understand what your insurance policy says. And then you kind of tailor your standard operating procedures so that, God willing, this will not happen. But if it does, and you have bound coverage or paid for a special endorsement, that you're able to fully, kind of cash in on what that sublimit amount might be. All right. Looking at the questions, none. We're going to continue to roll here. Consumer court cases is kind of our last segment here. There was a case, I call it the Hoffman case, and Will know this. When I read this quote, it really summarized what I thought the courts would be struggling with as it relates to consumers losing their life savings in connection with the real estate transaction. And it's this word or this term, novel issue. So the judge in the case puts this quote on the record: "The case presents a novel issue requiring in the analysis of who bears the responsibility for escrow fraud that took place." Why am I highlighting this? Rarely is there a novel issue in court. You can typically, and the lawyers do a good job at this, well, this look like this. And because this looked like this is the case precedent that you can apply to this outcome in these set of facts. A novel issue says, wait a second, we don't have case precedent on this. And the reason why is that the proximate cause of all of these scams is the fraudster. It's not the buyer or the title company. It's not the title company and the mortgage lender being paid off or the seller. It's the bad guy who's not in court. And that's what's so interesting. In most civil cases, you have the two parties that were involved in the deal. And here, because of identity impersonation and social engineering, the main bad actor, the person that started this whole bad chain of reaction in events, is not here. So the novelness is the fact that we're missing a very important person, and we're left with victim versus victim versus victim, essentially, because we're all victims in these things. And who really is the most sympathetic victim? And does it rise to the level that I'm willing to force somebody to open their wallet to make them partially or fully whole? And that's the problem that we're having on the consumer side. So why are they complicated? There's a ton of legal theories, and they're very unique, and uniqueness costs money. I can just say it. Long drawn out legal cases. I would dare say, to get through summary disposition, if you were sued by a buyer, low side would be $100,000 in legal fees if they have good counsel, and probably closer to $150,000 to $200,000, just because of all the layers that the court would have to go through to figure out, does this stick or does something else not stick? And as you know, with the average loss vector of 200 or less, we don't have a lot of precedent here because they're just not worth going the distance. And I hate to say that, but it's hard to litigate over a $200,000 issue. And I'm not saying that in a cavalier way. I just know that most billable rates start at $500 for an associate right now, and many of them for litigators have a comma in their hourly billing rate. So 6 cases right now that stood out to us that you could kind of call the ball a little bit on how precedent is landing. One of them is Hoffman. So Hoffman receives a spoofed email, and they wire just under $300,000 to a fraudster during a real estate closing. The concern here is that they found they're hanging their hat. The court is hanging their hat on a couple things. One, is there a fiduciary duty if you're holding escrow funds? And the answer is possibly. So they survive summary disposition on this idea that we believe a fiduciary duty may exist when you're standing in a bailment or some type of escrow function with an IOLTA or escrow account. The other significant thing that happened was there's something called the economic loss rule. So the economic loss rule says if I'm in contract with Will to buy his car and he doesn't sell me his car, I could sue him for breach of contract and I could prove economic loss. But I couldn't sue him for tort of negligence or some other tort-based damage because I've got my economic losses made whole. The court skirted around that and said, wait a second, the economic loss rule is not going to bar the plaintiff from recovering economic damages based on fiduciary duty in tort. It's significant. For those of you that are attorneys that would get it, it is significant. because there's this idea of, well, I didn't have an actual escrow agreement with the title company. It was implied. It was through course of performance. So the court dismissed breach of contract due to absence of a material contract, but reversed the trial court's judgment, which did allow Atlas out on this whole thing, and what's called remanded it back for them to analyze further the breach of fiduciary claims. Had the economic loss rule stuck, they would have been out on breach of contract, and Atlas would not have anything to talk about after. So again, what does all this mean? Breach of fiduciary may even transcend the lack of a formal agreement and may be interpreted as an obligation. Similarly, we have Margot versus Arizona Escrow. And I'm not indicting any of these companies. I don't know them. This is all public record. And again, this just were of the, I don't know how many cases we looked at, 100 or so, maybe more. These are the ones that kind of stood out. So here's Margot buying a Subway restaurant franchise in the state of Arizona. And Arizona Escrow was essentially acting as the escrow agent, and she fell victim to a wire fraud and sued for negligence, breach of fiduciary duty, and breach of contract. The Arizona case, again, economic loss rule did not prevent her from seeking a breach of fiduciary duty claims. The court dismissed her contract claim because I think her attorney just messed up on some of the dates. I think the statute of limitations had kind of run on the contract. But as it relates to fiduciary duty, they allowed that to go forward. So where do we find ourselves here? We find ourselves in a gray area, or a rather opaque area. And that's never good for us as an industry, because we want clear dividing lines. Tell me what to do. I'll update my standard operating procedure and I'll execute against that. And I'll bring my insurance partners in to overlay that if we make a mistake, we still have coverage. That's our best case scenario right now. So what I think the takeaways that we found is, if you're a custodian of funds, if you're serving in an escrow capacity in any way, then there's likely a fiduciary responsibility that you could face. I don't want to talk about every jurisdiction. Some jurisdictions did dismiss cases where a consumer lost money and they didn't find fiduciary, okay? But I think out of an abundance of caution and being more conservative, I think the best position would be, okay, we could get drug into more of an extended conversation. The commonalities that we found is certain theories kind of move a little faster through and some are easily dismissed. Breach of Consumer Protection Act, UDAP, intentional fraud, concealment, judges see through that. What they're struggling with is, you sit in a very important position by taking in other people's money with the responsibility of dispersing those funds out safely in a real estate transaction. And oh, by the way, you're paid to do it. You're paid a closing fee, you're paid an escrow fee, you're paid a wire transfer fee, you're collecting these things. And I think the damages are going to vary between, obviously, jurisdictions and the specifics of each case. I think the more heart-pulling the case is from a factual standpoint, the more damages a title company or a brokerage could face. Courts are divided on whether or not explicit agreements are required versus implied agreements. So we've seen cases where there was no express escrow agreement, so therefore a fiduciary wasn't applied. Others said, wait a second, in the course of performance, you filled these duties and it did apply. So again, a little bit of jurisdictional uncertainty there. A new case, or a recent case, for those of you that haven't been following this, the Dr. Kenigsberg case is probably one of the most widely publicized. Here's a doctor that has a house and a vacant lot next to it. He goes on an extended vacation to find a $1.5 million home being built on his vacant land after the developer had paid over $300,000 to secure the property, all because Dr. Kenigsberg was impersonated while he was out of the country. So this lawsuit, which settled recently, of firms. So there was kind of an affirmation that was interesting. I think this settled, do I have a quote here? Yeah, this settled middle of April of this year. The ownership of title through a quiet title action was confirmed by U.S. District Court. So the U.S. District Judge signed off, because remember, you have a fraudulent deed that needs to be expunged. Well, the only way to do that is to do a quiet title action. So quiet title action was actually, and this is the kicker for the doctor, he had to hire an attorney to expunge the fraudulent deed, but the district court signed off and essentially provided the quiet title judgment in favor of the doctor, which in that moment would have put him in fee title with all improvements to the property. As part of that, though, he entered into a settlement agreement, and he got some, I'm sure, very, very good amount for allowing the project to continue on the part of Skytop Partners. But what I found interesting is, as part of a stipulation in order, the quiet title judgment was entered, and then they settled the case. So outcomes again, so high level, let's focus on prevention. Let's focus on the standard of care. It's very clear banks and insurance companies have well-defined precedent and codified law under the Uniform Commercial Code. The consumers are a jump ball, and it's been very active, guys. I mean, you probably saw it. We've seen it across the country. They stepped up, over the holiday weekends on all forms, seller impersonation. In West Michigan here, we're sitting on over 60 reported cases of seller impersonation since the beginning of the year. We'll probably triple the amount reported in West Michigan over last year, just a staggering amount. And they're after, like I say, they're after everything: EMD, cash to close, payoffs, you name it. This is likely a self-insured risk. So for those of you, again, that haven't dove into the insurance policies, you say, look, I got 1 million, 2 million, I got 2 million, 5 million. I'm pretty much covered for most cases. If you do have electronic funds transfer fraud or wire fraud protection, I will guarantee the sublimit is something closer to 100,000, maximum of 500,000, if you're using certified and some of our carriers that have a specific endorsement. Most of you would be sitting on 100 to 250,000, period. So what do we think about? It's today, right? We're educating ourselves. We're getting a better understanding of how courts, right? We've got the executive branch that enforces through regulation. We have the legislative branch that codifies law, such as the UCC, and then we have the judicial branch that interprets these things. And the judicial branch is where the rubber really does hit the road as it relates to who's responsible. I can't stress enough taking a look at your incoming and outgoing funds transfer procedures, looking at identity verification as a meaningful layer on the front end of the transaction to make sure that everybody's dealing with who they believe they're dealing with. So we've got certified match now to identify any party in a transaction. Have to use that on all vacant or absentee sellers. We're doing that on every single file for our organization. You've got payoff protect for all mortgage payoffs, but then making sure that you're really sending the wiring information of your agency or your company to the buyers early in the transaction, and then reminding them that that will never change, even if they don't intend to bring a wire to closing. I'll say it, I've said it before, just saying, look, no wires, always bring a check is not wire fraud prevention, because the fraudster is going to make up an excuse in an email spoofing you or the agent or the mortgage processor or mortgage lender on why a wire needs to be initiated, and there's nothing to benchmark that against. The technology of certified and other layers of email security and proactive phishing tests, network security and monitoring, our IT budget in all companies has gone up pretty much exponentially the last 3 years because of all the additional layers to try to catch social engineering and just more readiness on the part of the customer and the employee. If you don't have an incident response plan, Alta does a great job. There's one on the Alta website. I believe it's in their resources panel or something. I'm probably saying this wrong. And if there's someone on Alta on, you could put it in the chat now. but follow an incident response plan. You don't do this after an incident, you do it before. So who's in charge? Who would communicate with the sending bank to alert of a wire transfer? What if there's been an email account compromise or a ransomware demand? You have to have an incident response. And again, revisit your insurance policy to make sure that there's no error gap between standard operating procedure, the incident response plan, and what your coverages ultimately say. So if you'd like a copy of the wire fraud report, if you haven't seen this yet, you can, this isn't a scam. This is the QR code. If you're not comfortable with that, go to our website and we have it published there under our resources tab. But I invite you to really take a look at that. And then it goes much further into what we did today, but you'll see the themes kind of bubble out. And then use this as education. When I say sued for wire fraud, brokerages, real estate agents, law firms, we focused a lot on title companies that were involved in these things. But you know, it's a laser printer and it doesn't cost any more to add 5 people on a list of defendants as it does 1. And these are ones where with summary disposition, meaning I appreciate you're suing me here, but there's nothing to talk about in title company. You got to take this stuff on the chin. So are there any questions, guys? I know we're running a little bit early, which I'm fine with. I can give you the gift of time back. I'll just give it another couple seconds. You can put it in chat or in Q&A. I have both up. All right, well, hearing none, thank you. For those of you that are customers, we cannot thank you enough for the continued trust and support that you put in our team. And we're continuing to advance the platform to keep pace with what we're seeing as an evolution. So with that, I'm going to sign off. I'll give you some time back and stay safe out there, guys. Take care.